Narito na naman ang mainit na balita mula sa mundo ng politika. Isang nakakagulat na balita ang yumanig sa bansa ngayong araw matapos kumpirmahin ng ilang source na biglang nawala si dating Senate President Vicente Tito Sotto. Ayon sa mga ulat, tuling nakita mo si Sotto kagabi sa isang pribadong meeting bago tuluyang mawala at hindi na makontak ng pamilya at mga kaibigan. Naging laman ng social media ang kanyang pagkawala matapos kumalat ang umano'y scandal video na di umano'y may kinalaman sa isang mataas na opisyal ng pamahalaan. Habang lumalalim ang investigasyon, ilang netizens ang nagdududa na may kinalaman umano ang Malacanang sa misteryosong pagkawala ni Sotto. May mga nagsasabing posibleng tinatago o pinoprotektahan siya upang hindi na lumaki pa ang issue. May mga balitang lumabas na sinusubukan ng ilang opisyal na isuppress ang pagkalat ng nasabing video na di umano'y nag-uugnay kay Sotto sa isang malaking anomalya. Hindi rin nakaligtas si Pangulong Ferdinand Bongbong Marcos Jr. sa isyong ito, matapos mapaulat na may mga taong malapit sa kanya na sangkot sa tinatawag na cover-up operation. Ayon sa ilang political analysts, kung mapapatunayang totoo ang mga aligasyong ito, malaking dagok ito hindi lamang kay Sotto kundi pati sa imahe ng administrasyon. Hanggang ngayon, tikong pa rin ang bibig ng palasyo sa issue at tumatangging magbigay ng opisyal na pahayag. Patuloy naman ang paghahanap kay Sotto habang umaapaw ang mga spekulasyon online. Ang ilan ay naniniwalang sinadya umano ang kanyang pagkawala para mapatahimik siya, habang iba naman ay umaasang ligtas lamang itong nagtatago. Sa kabila ng mga haka-haka na nanatiling tanong ng publiko, nasaan na nga ba si Tito Sotto at ano ang tunay na laman ng skandal na ito? Ang katotohanan ayon sa mga taga-subaybay ay posibleng mas malalim kaysa sa inakala ng marami. At yan nga ang mga balitang ating pagkakatutukan, at kung bago ka pa lamang sa aking channel ay huwag kakalimutang mag-like, share and subscribe para updated ka sa mga bagong balita dito sa Tatak Pinas.
To the February 5, 2025 adjournment. But they have, erroneously believed that the said adjournment is the same adjournment with the sine die adjournment that ends a Congress. It is not. February 5 did not terminate the 19th Congress as stated in the decision. The sine die adjournment of the 19th Congress was on June 13, 2025, wherein the last session day was last June 11. Mr. President, and for the information of the public, there is a world of difference between adjournment versus adjournment sine die. Sa atin, pag nag-adjourn tayo for the Christmas break, nag-adjourn for the Easter break, nag-adjourn for the election period, nothing dies. The treaties, bills, resolutions, anything filed continues. It is never archived. Well, perhaps the lawyers of the ponentes did not realize that, or they were not familiar. Table the motion to dismiss. A motion to table has a higher precedence than a motion to dismiss. Thank you, Mr. President.
Mr. President, may I have a quick reaction to the manifestation of the gentleman?
The gentleman may do so if he so desires.
Mr. President, in the answer of the Solicitor General in behalf of the House of Representatives, there was already a categorical admission that the three initial complaints prior to the fourth one were dismissed because they were all archived. As I have said, archiving is not part of the rules of impeachment of the House of Representatives, but they just did it. Palusot lamang po yun, Mr. President. Paano mo i-archive nang hindi mo susundin yung tatlong steps na sinasabi ng sarili nilang tuntunin? These are not baby steps. These are constitutional steps. At kanina po ipinakita yung slides na yung inclusion in the 10th session day is constitutional. The referral to an appropriate committee is constitutional. There was no referral to any committee. ang ginawa po nila, tinransmit nila sa Senate without requiring themselves to observe another provision of their own rules. This is to refer to the Justice Committee, where the Vice President might probably be given at least a modicum of right to defend themselves. That is what we call due process. Wala po eh. Inakala po nila na kapag may 1/3 na or more, ay pwede na nilang huwag gamitin yung Section 2 ng kanilang rules. Hindi po nakalagay yun eh. So hindi na po kailangan na i-distinggi pa natin yung adjournment and sine die adjournment. Kasi inadmit na rin po na in-archive nila kahit na wala po sa tuntunin. Kanina sa manifestation, tinanong din po. Kung wala tayong jurisdiction, paano yung unang initial proceedings? Pwede po yung initial proceedings ninyo will be considered under the doctrine of operative facts. Hindi pa po na-declare na wala pang jurisdiction ng Senate at that time. Ngayon lang po nangyari. Kaya po yung ginawa ng Senate of the 19th Congress, tama pa rin po eh. Wala pa pong declaration noon. Kaya lang, ang kagaya po ng aking clarification na sinabi, all these initial proceedings conducted in the Senate of the 19th Congress were not officially transmitted to the 20th Congress, where I myself belong, a Congress of different composition. So yun po ngayon, naharap tayo ngayon sa issue na talagang tayo lamang po ang gagawa because there is no other agency of government that will execute that decision of the Supreme Court. Only the Senate. So may I go back to the first question, to the original motion, Mr. President.
Mr. President, if I may.
Majority Floor Leader.
Thank you, Mr. President. With the indulgence of my colleagues, Mr. President, our Senate Minority Leader, Senator Sotto, and first movant of the motion, Mr. President, Senator Marcoleta, may I respectfully appeal, Mr. President, of our, and remind, Mr. President, our colleagues of our concurrence during our caucus held last week, that we will debate on this and talk about this and discuss this matter, Mr. President. But if the Minority Leader would continue to insist his motion, Mr. President, we have no other choice but to dispose with the motion of the Minority Leader, considering that it takes precedence, Mr. President, with the motion of Senator Marcoleta.
It is the understanding of the Chair that during our all-member caucus, which the Chair announced in plenary, that it was agreed unanimously by all the members that we will be discussing, debating, and acting on the Supreme Court decision on a date certain. And this was the date certain that was agreed upon in caucus. Maybe hear from the distinguished Minority Floor Leader if there has been a change in that position given on that date when we had an all-member caucus.
Mr. President, I as a matter of fact, concur with what you said. But during that time when we discussed it, there was no MR filed. There was no motion for reconsideration filed by the House of Representatives or the Solicitor General. So it becomes a different, it develops into a different scenario now that there is a motion for reconsideration. Because again, my question was not clearly answered when I said, what happens if we move to dismiss as what? As a Senate or as impeachment court? I think that is one of the questions that is going to be posed by another member of the Senate, and we wish that you could recognize them to continue debate on this matter before we decide. But again, my answer is that there was no motion for reconsideration when we agreed to decide on August 6 on the motion to dismiss. That's why my motion is not against the motion to dismiss, Mr. President. It is merely a motion to table the motion to dismiss, which you may be able to take up on the floor even tonight or tomorrow. A motion to table is alive always in parliamentary rules, and you may take it up anytime. Then we can take up the motion to dismiss after that, Mr. President. Thank you.
We note the intent of the distinguished minority floor leader, but the chair would therefore like to make some points known before we act on the motion.
Mr.
What is the
President,
pleasure of the majority floor leader?
Mr. President, upon conferment with the minority leader, Mr. President, he is amenable, Mr. President, for us to continue with the discussions and debate on this particular topic, Mr. President. And so with that, Mr. President, may I move that we recognize the distinguished gentleman from Cavite, Senator Panfilo Ping Lacson, to ask his questions, Mr. President.
Well, first, the chair would like to thank the magnanimity
Mr. President.
of the distinguished minority floor leader in order for us to be able to continue with the debates. The gentleman from Cavite, Senator Lacson, is recognized for his interjections with leave, of course, of the gentleman who has the floor, Senator Marcoleta. You may proceed, sir, if Senator Marcoleta so desires.
Thank you, Mr. President. This is not an interpellation. Rather, this is a manifestation to be followed by a parliamentary inquiry.
The gentleman may proceed then.
Mr. President, I've been diligently reading and reviewing the rules of the Senate since I've been out of this august chamber for 3 years. Nowhere in our rules can I find a provision on a motion to dismiss, as submitted by the honorable gentleman from Tarlac. Neither is there a supplementary application of the rules of court to offer a space for such motion to dismiss, except perhaps in the committees performing their legislative inquiries in aid of legislation. Obviously, we are now assembled in plenary, not as an impeachment court, but as a legislative body, and I cannot relate to a motion in this plenary to an issue that involves a collective decision that falls solely and exclusively under the jurisdiction and authority of an impeachment court. Having said that, Mr. President, my parliamentary inquiry is addressed, of course, to the Senate President. Mr. President, how do we deal with the pending motion? I refer to the motion to dismiss. Shall we even take it up or deal with it? Kasi wala po sa rules natin. Paano wala tayo pong guidelines? Kasi wala po sa rules natin yung motion to dismiss. So anong guidelines ang susundin natin in addressing the motion to dismiss submitted by the Honorable Marcoleta? Assuming arguendo, Mr. President, that the motion is voted upon and adopted by this body, what if, Mr. President, the Supreme Court reverses itself when it rules on the MR filed by the House of Representatives through the Solgen? Shall we also backtrack and reverse ourselves in dismissing the impeachment case? I pose that question, Mr. President. Thank you.
Thank you, Senator Lacson. To respond, we were faced with this question, but the very people asking us to wait right now were the very same people who were telling us before to ignore the pendency of a case in the Supreme Court precisely regarding this impeachment complaint. They were egging the Senate, even if we were on recess, to precisely proceed with the trial in spite and despite the pendency of cases in the Supreme Court. And the chair, with an abundance of caution, same with us good senator right now, decided to afford the Supreme Court time during the recess to decide on the matter. And when they did not, the Senate, in accordance with its duty, convened the impeachment court when we resumed session, given that we cannot conduct impeachment proceedings that have not yet begun yet during the recess. To answer the query with respect to motion to dismiss, this was actually done, although not via a motion to dismiss, but a motion to archive in relation to the impeachment complaints of then President Estrada and Ombudsman Gutierrez. In fact, in the case of Ombudsman Gutierrez, it was our distinguished Minority Floor Leader himself, acting as Majority Leader, I believe, who moved that the case be archived, given the resignation of then Ombudsman Gutierrez for being moot. In the case of President Estrada, the case was likewise archived for being functus officio, given that EDSA DOS happened and a new president was sworn into office. Your Honor, I believe the chair believes that we will have different interpretations of the effect of the Supreme Court decision. But ultimately, as I discussed with the Majority Leader earlier, once a decision is made by the Senate and the period to seek a reconsideration of that decision put to a vote has expired, the next logical step would be to archive so that it will be made part of our records. It is the position of the chair, subject to the wisdom of the plenary, Your Honor, that given the Supreme Court decision that the Senate never acquired jurisdiction over it, that the proceedings and the articles of impeachment were null and void ab initio. Indeed, there might not even be anything to dismiss, and the procedure would be more properly to archive, similar to what we have done in the past, so that these proceedings will still be made part of the Senate's records. But we will cross that bridge once we put it to a vote, Mr. President.
I go
Your
back
Honor.
to my previous question, Mr. President. Anong gagawin natin sa motion to dismiss? How do we deal with it?
May I
We are in
answer,
plenary
Mr.
as a legislative body. We're not an impeachment court. So yun ang tanong ko po, Mr. President. Yun ang essence ng aking parliamentary inquiry.
The predisposition of the chair is what I stated, but subject, of course, to the wisdom of plenary. Maybe here from Senator Marcoleta, with respect to his ideas, given that he is the proponent
Mr.
of the
President,
motion.
it is true that the motion to dismiss is not part of our rules. But it is part of our rules po yung pagiging suppletory application po ng rules of court. In the rules of court, yung korte po can motu proprio dismiss a case kung wala pong jurisdiction. And considering that the rules of court has become part of our rules, that's why I use the motion to dismiss. Pag wala pong jurisdiction, halimbawa, sa isang korte, collection case po ito, 5,000 pesos po yung pinal niya, dinismiss po ng court kahit hindi pa sumagot yung kalaban, Mr. President, kasi ang jurisdiction po ng korte hanggang 3,000 lang. Ganun po ibig sabihin nun. Minsan po, wala pong, hindi po verified yung complaint, dinismiss. Sa motu proprio, talagang dinidismiss. Paano po kaya kung sinabihan pa nga na the Senate didn't acquire jurisdiction over the case? Mas lalo po sigurong dapat nating panindigan na talagang i-dismiss na po natin, Mr. President.
Senator Lacson is recognized.
Again, I refer to our rules, Mr. President. Wala rin po ako makitang suppletory application sa rules of the Senate pagdating sa plenaryo. Pwede pong gamitin ito sa mga committee hearings.
Sa impeachment.
Inquiry in aid of legislation. But we are not there. We're here in plenary. Maski po basahin natin na 100 beses ang ating rules of the Senate, wala pong suppletory application sa ating rules. Thank you, Mr. President.
The point of Senator Lacson, insofar as that is concerned, is well taken. Senator Pangilinan.
Just on the point of
Is recognized.
suppletory, the rules of court being suppletory. Mr. President, the rules that are suppletory presupposes that there are no rules of the Senate or the Senate impeachment court. In other words, in the absence of a standing rule or provision of either our Senate rules or the Senate impeachment court rules, then we refer to the rules of court as suppletory to our rules. But in this case, the Senate impeachment court has a specific rule Resolution number 39. Upon presentation of the articles to the Senate shall specify the date and time for the consideration of such articles. Unless the Senate provides otherwise, it shall continue in session from day to day until final judgment shall be rendered, and so much longer as may in its judgment be necessary. In other words, as an impeachment court, of course, not as a Senate in plenary, but even that is now being debated because this representation believes the sole power to try and decide impeachment cases is the impeachment court and not the Senate in plenary.
Mr. President,
Majority Floor Leader.
Mr. President, next to interpolate, Mr. President, on the list of this representation is the distinguished gentleman from Taguig and Pateros, no other than Senator Alan Peter Cayetano. I move that he be recognized.
Your Honor,
It's
the
not an
Chair-
interpellation yet, Mr. President. A follow-up point to the point of Senator Lacson. If the SP
lady may
and
proceed.
the gentleman. Thank you, Mr. President. And with the indulgence, as I said, of the good gentleman from Taguig and Pateros, nabanggit na rin po, Mr. President, pareho ni na Senator Lacson at Senator Pangilinan, yung usapin ng tayo ba, Senate or Senate Impeachment Court ba? So this is a point of inquiry, actually, a brief point of inquiry, Mr. President, related to the motions at bar now. The question presented to the body is related to an ongoing impeachment case, which is within the jurisdiction of the impeachment court. Should we not first have the newly elected senators take their oaths as senator judges and convene as an impeachment court? I note, Mr. President, that the Supreme Court decision is not yet final. As colleagues have mentioned, a motion for reconsideration has been filed by the House of Representatives, and the court itself, the Supreme Court, has given 10 days for the Vice President to comment. So yung point of inquiry ko nga po, Mr. President, hindi po ba dapat pasumpain na muna ng presiding officer with us convened as an impeachment court, yung mga bagong halal na senador para makapag-convene po tayo bilang impeachment court at i-treat yung mga motions at bar. Salamat po, Mr. President.
Noted and entered into the records. What is the pleasure of the Honorable
Just a very quick intervention. Very quick, Mr. President. With the
Pangilinan?
permission of
Yes,
our
you may
Mr.
proceed, sir.
Yes, Mr. President, and we place this on record after reading the ruling, the decision of the Supreme Court. Mr. President, the Supreme Court referred to the Senate impeachment court repeatedly. And therefore, it is the Senate impeachment court that was also impleaded. It is the Senate impeachment court that may, if it opts to, file a motion for reconsideration. And therefore, this motion to dismiss, we believe, should be forwarded to or tackled by the Senate as an impeachment court.
Your Honor, just on that point, the parties mentioned in the case is not the Senate impeachment court, but the Senate. And the dispository section of the decision makes mention also of the Senate. If I may quote, consequently, the Senate did not acquire jurisdiction to constitute itself as an impeachment court. That's the decision of the court in Duterte v. HOR.
Mr. President, and we will go back to the earlier manifestations
The
of...
mic, please.
We will go back to the earlier manifestations of the minority leader. Yes, the Supreme Court ruled that we have no jurisdiction. Yet, the decision is flawed in terms of the facts on procedure, the one-year bar, and on due process. This is at least, of course, our assertion. And therefore, should we not wait for a motion for reconsideration to be resolved before we proceed and vote on the matter that has removed from the impeachment court jurisdiction? Should we not at least assert the power and the prerogative under the Constitution of the Senate impeachment court in terms of
with the rules of Congress. As I said, this is a world of difference. Now, this is a transcendental case. Ang laking constitutional issue. Wala man lang oral arguments, or at the very least, a consultation with some members of Congress or members of the bar na nakakaintindi ng rules ng Congress regarding the procedure. In that matter alone, Mr. President, kasabihan ninyo mga lawyer, falsus omnibus, falsus unos, falsus omnibus. Mistake in one, mistake in all. In that manner, they wouldn't have decided based on their unfamiliarity with the legislative process. May mali agad eh. Pati ba legislative rules natin gusto nilang palitan? Ganun ba yun? Maybe not everyone may appreciate the importance of the legislative calendar of Congress. But us, it is a big deal. That's why I'm stressing this point.